Welcome to the deep dive, where we take complex topics and try to boil them down to the essentials for you.
Yeah, exactly.
Today, we're continuing our journey through U.S. patent law using the main guidebook, the Manual of Patent Examining Procedure, or MPEP as it's known.
Right. Think of this as your guided tour.
And this is part of our educational series on the MTEP, focusing section by section.
That's right. And today we're diving into chapter 2100. That whole chapter is about patentability, what actually makes an invention, patentable.
Okay. And within chapter 2100...
We're zeroing in on section 2109.01 specifically.
2109.01. And that deals with joint inventorship, right? Something that must come up a lot.
It really does. This section is all about who legally gets recognized as an inventor when, more than one person chips in on an idea.
Okay, let's unpack this. What's the the core principle of joint inventorship according to this section?
So the central point in 2109.01 really revolves around contributing to the conception of the invention.
Conception.
Okay. Yeah, conception is like the formation in the inventor's mind of the definite, permanent idea. The complete invention, basically, as it's going to be put into practice. So this section clarifies it's about who contributed to that initial thought.
So it's not just about who put in the most hours, maybe, or who was physically building the thing.
Precisely. The MPEP makes it super clear. Things like working side by side physically, contributing exactly the same amount, or even having a hand in every single claim in the patent. None of those are required.
Oh, okay.
Someone can definitely be a joint inventor, even if their contribution was, let's say, focused on just one specific piece of the puzzle. They don't need to be involved in the whole process from start to finish.
Got it. So it's really about that intellectual spark, the contribution to the idea. You mentioned conception again. Can we distinguish that a bit more clearly from, say, the actual building or testing phase? So what does this all mean practically?
Right. Think of it like this. Conception is the what and the why of the invention. It's formulating the idea in your head.
The mental part.
Exactly. Reduction to practice, that's more the how. Actually building it, proving it works. Section 2109.01 says inventorship is all about who contributed to that what and why.
Okay.
So someone could have the key insight, be a genuine inventor, even if they never actually, picked up a screwdriver or wrote a line of code to build it.
Right.
And conversely, someone might meticulously follow instructions, build something based entirely on another person's concept, but if they didn't add any inventive thought of their own, well, they wouldn't necessarily be a joint inventor.
That makes a lot of sense. It clarifies that distinction between the idea and the execution. Now, what if someone's contribution feels, well, kind of small, maybe focused on just one little element within one of the patent claims? Could they still be a joint inventor?
Okay, here's where it gets really interesting. Section 2109.01 explicitly states that, yes, even contributing to just one aspect or one element within a single patent claim can be enough.
Wow.
Yeah, enough to make someone a joint inventor. You don't need to contribute to the whole claim, let alone all the claims.
So a contribution that might seem minor could actually have pretty big legal weight in terms of who owns the invention.
Exactly right. And the MPEP actually points to some important court cases to back this up. A classic example is Ethicon Inc. v. United States Surgical Corp.
Okay, what happened there?
Well, in that case, you had an electronics technician. He figured out one of two different ways to make a specific part of the invention work something described in just one limitation of the claim.
It's just one part.
Right. And even though the rest of the invention came from someone else, the court said, nope, his conception of that specific alternative makes him a joint inventor.
That really drives the point home. Are there other examples like that, maybe showing how collaboration itself can lead to joint inventorship?
Yeah, definitely. The section also mentions cases like Kimberly-Clark Corp. v. Procter & Gamble and also Dana-Farber Cancer v. Ono Farm Co.
Right.
These cases kind of illustrate how joint inventorship can pop up in team settings. Like maybe someone throws out a basic idea in a meeting, and then someone else takes that idea and builds on it, adding something genuinely new and non-obvious that becomes part of the final claimed invention.
Yeah.
In that scenario, both people could be considered joint inventors.
Ah, okay.
It really shows that the aha moment isn't always one person in isolation. It can be this sort of back and forth, a buildup of shared ideas.
So it's not just the first flash, but also who significantly develops and shapes that idea into what's actually claimed in the patent. Okay, shifting gears slightly. What if a mistake is made? Say someone is listed as an inventor on the application but shouldn't be, or maybe someone who should be listed was left off. Can you fix that?
Oh, absolutely. Yeah, the USPTO knows mistakes happen. Section 2109.01 covers this. Sometimes an inventor is wrongly named or a key contributor gets accidentally overlooked.
Right.
The MPEP allows you to actually amend the application to correct the inventorship. You can add the right person or take off someone who was included by mistake.
That's good to know. So it's not necessarily fatal if there's an initial error. Are there like conditions or hoops you have to jump through to make those corrections?
Yes, a couple of important ones. First, and this is critical, the error itself must have happened without any deceptive intent.
Oh, okay. No funny business.
Exactly. If it looks like someone was deliberately left off or included wrongly, that's a whole different, much more serious problem. Second, you need the right paperwork.
Naturally.
Yeah, typically you'd submit an updated application data sheet, or ADS, showing the correct inventors, and pay any necessary fees. Depending on where you are in the process, you might also need new declarations from any inventors you're adding.
Makes sense. Documentation is key. Now, here's another practical scenario. What if you have, say, 3 inventors, but one of them just refuses to sign the papers? Or maybe you genuinely can't find them. Can the other 2 still file the patent application?
That's a really common practical issue. And yes, Section 2109, Throwaway 1, addresses it. It explains that even if one joint inventor is unavailable or just unwilling to sign off or participate, right, the other inventor or inventors can still go ahead and file the application on behalf of the whole group, the whole inventive entity.
Okay, so the whole project isn't necessarily sunk.
Not necessarily, but there are specific rules for doing this, and it's ultimately overseen by the director of the USPTO to make sure everything's handled properly and the missing inventor's interests are still considered.
It really sounds like Section 2109.01 offers a pretty thorough roadmap for dealing with joint inventorship, which can definitely be tricky territory. And the big theme seems to be that intellectual contribution to the idea, the conception, is what truly matters.
That sums it up nicely. Yeah, the core message isn't about hours logged or who touched every component. It's about who genuinely contributed to that original inventive concept that ends up being defined in the patent claims.
Yeah.
And the fact that there are procedures for fixing errors and dealing with reluctant inventors, it shows the USPTO understands that innovation today is often, a team sport.
Definitely. So, thinking about how collaborative most innovation is now, maybe for you, the listener, how might really understanding these joint inventorship rules affect how you approach future projects with colleagues or how you think about your IP strategy? It certainly gives you something to mull over, doesn't it?
It really does. And just one final very important point we need to make. This audio summary is for education and information only.
Right.
It's based on our reading of the MPEP and the cases, and it was prepared using AI tools like ChatGPT and Notebook LM, so there could be errors or things left out. It's absolutely not legal advice.
Definitely not.
For real guidance, you always need to consult the official MPEP itself, talk to a qualified instructor, or, of course, a registered patent attorney or agent.
Agreed. Please do that for any specific questions. And before we go, a huge thank you to Mike Shepard, our creative director. He was the driving force behind organizing this whole MPEP summary series and making this deep dive happen.
Yes, thanks, Mike.
And that wraps up this installment. Join us next time as we continue to dig into the fascinating details of U.S. patent law.